later. There's a heads up.
Everybody, I'm going to come out of the meeting and rejoin via my mobile because I can't get my camera to work. So hang on a second. I'll be with you in a moment on my mobile.
Sure. Everybody enjoying the weather?
Yes.
Yeah.
Beatrice?
Yeah. Almost too much for me. I can't, it's too hot. It's not so bad today. It's a bit less sweaty today.
Yeah, quite. We'll just wait for Elaine to join. Hello, George. Hi.
Hi
Good
there.
to see you. Hi. Well, while we're just waiting, Elaine, I'm sure will pop up in just a moment. But I think the government's intended reforms are, from what we can gather, intended to be put in the context of their plan to make work pay, and that I think is clear from the way that they're proposing the right should be extended. There's going to be primary legislation which should be introduced in this parliamentary session under a new employment rights bill, and that, I think, amongst others, will aim at banning what they regard to be exploitative measures such as zero-hour contracts, the hire and refire, and then coupled with granting additional day one rights to workers, changing eligibility criteria for the statutory sick pay, making flexible working the default, and indeed other commitments. So if I kick off with probably what I regard to be the most important one, and that's not to say it is right, but it's the unfair dismissal and changing across to a day one right. I think that will be hugely influential in terms of the way employers recruit. I think the amount of time they spend going through an interview stage, formalizing or making things very much more formal in terms of documentation, policies, certainly probationary periods, contracts. They're all going to be given a lot more importance, and no doubt grievances on the other side too. And we can see there's going to be quite a sharp end. So, I mean, let me throw it open to the floor. I mean, what do you think?
I noticed that they said that they wanted to consult with employers about what they're proposing. So at what stage, so just in terms of the process of getting all the legislation through, how does it work? So they pull together, because when I think everybody went into a blind panic when they said they were going to introduce all this legislation within the first 100 days, and and the thousands of emails coming, say, people trying to sell you stuff to make sure that you know exactly what's coming and all of that kind of thing. And it was just like this kind of whole furore about it. But what is the actual process? Perhaps you could talk us through that, because then that might help us, well, it certainly helped me manage my clients' expectations about how quickly these things might come into place, and actually if they will come through as specified at this point in time. Because if they're going to consult with employers, for example, about day one rights and the CBI, etc., what might that change things?
Yes, I mean, well, let me say first of all, I'm not a parliamentary lawyer. I'm sort of boxing way above my weight if I try to sort of launch into that. The short answer is I don't know. The consultation phase, I think, could be as extended, prolonged as they want to make it. I mean, what they've announced is it will be brought in this parliamentary session. So watch this space, I guess, because they don't actually have to consult with anybody if they don't want
No.
to. And if they're not thinking they're getting much engagement, or they don't like the answers they're getting, or they don't want to be seen to be prevaricating, and they want to drive it through and be very decisive, I think they'll just implement it. But I think there are a huge amount of knock-ons, and that's why I think they may be more thoughtful and more mindful of the commercial realities, because it's seemingly very good for employees. One of the articles I was originally reading about it seemed to suggest what they had in mind was it will change the job market, that employers will be a lot more flexible in how quickly they move, because they won't have in mind they have to attain 2 years service in order to have rights for redundancy, unfair dismissal, which is a good thing on the one hand, I think is possibly, to balance it, a bad thing on the other. If you're thinking about the integrity of your workforce, how much training, how much investment you put in terms of supporting employees, the culture you build, if you think it's going to become a lot more transitory and you're going to lose people as soon as there's better offer somewhere else, there's some negatives there, I think, that could be carried through. But I do think the process of recruitment will change every bit as much as retention of staff. So I'm afraid I can't answer, Ros, I can't answer the question. But I think it is certainly, I see it as a monumental change. And there's a lot to go through. I mean, what does anybody else think?
I'm a little confused regarding the differences between what you can and can't do during a probationary period and those immediate rights. So my biggest concern is, of course, when you employ someone, no matter how well you go through the interview process, etc., you don't actually know what you're getting until they start work. So if there was all sorts of press speculation, but then press often likes to speculate rather wildly, but there was all sorts of press speculation that once you'd employed them, you were sort of stuck with them, as it were. So maybe you could explain more about what we're still going to be able to do as far as is seen at the moment on the probationary periods. And I'd always felt that Britain was well regarded in getting the balance about right between somewhere like France, where the employees have all the rights and it's difficult to get rid of anybody, and there's somewhere like the States where employees have pretty much no rights. Well, as a small employer, I'm thinking, well, maybe I don't have any staff. Maybe they're all subcontractors or something. I think the potential for them to really damage small businesses is huge if it's not properly thought through.
Yes. If I answer first, I don't want this to be a question I'm very happy to engage, but I don't want to take over. I'm supposed to be chairing, so I want to gather in a sort of a better, a wider discourse. But if I just add a couple of points there, I've always thought personally that the probationary period is slightly illusory. Somebody doesn't have unfair dismissal rights until they get to the second anniversary. So the fact that they pass probation is a mark, but it is no more than that. It does not give them statutory protection. They have discrimination protection prior to even being recruited. So, there's a difference in what rights and entitlements we're talking about. The problem with making unfair dismissal a day one right is it doesn't matter how you've scrutinized somebody, what due diligence you've deployed. If you recruit somebody and they turn out to be very different from what you thought you were requiring, and that may even be in the guise we're talking, somebody who turns up for a full-time permanent role, Monday to Friday, 5 days a week, 9 o'clock till 5 o'clock in the afternoon, and they change and they say, I want flexible working. Thank you very much on day one, and I only want to work in the mornings. There could be a whole host of issues. What I think it would require is employers to justify, having followed an appropriate process, that it was reasonable and fair to terminate somebody's employment on the usual substantive basis, so capability, redundancy, conduct, some other substantial reason, and operation of law. You're going to have to fit in the usual way those defences to a potential claim of unfair dismissal. But what, of course, you will get is you'll get grievances, you'll get appeals, you'll get litigation, and that litigation now will be based on the assertion of statutory right, or possibly automatic unfair dismissal, discrimination in some instances allied to the express termination, and whistleblowing. You'll just simply be front loading all the issues that would have arisen with any 2-year plus termination from day one. So Kevin, I think you're moving the goalposts so considerably.
Yeah.
Someone else is going to speak. Someone's put their hand up.
Yeah, sorry, I was just going to following Kevin's question on that same point, just pretty much just reiterating what you just said, in that what I envisage the key change will be is that there may be a desire from employers to elongate those probationary periods now, because as you said, essentially probation currently is that period of time where an employer gets the opportunity to see if an employee, a candidate, is fit for the role, and if there are any concerns that they have, just to ensure that once that period has been satisfied, that they do become an employee. As the law currently stands, they get employee status, but as previously just said, they wouldn't accrue those protective rights until they'd accrue those 2 years of service. So this change just means that as soon as the probation has finished, that all those rights that you would have, those statutory rights for the right not to be dismissed for an ordinary unfair dismissal. Obviously, automatic unfair dismissal is a day one right already, but ordinary unfair dismissal for a capability, conduct, or things of that nature, you'd have to have 2 years to bring that as the law currently is. So what this change would do, I envisage, is not potentially open the floodgates for a lot of claims as soon as probation is done, but that is a possibility. So I've already had inquiries from clients saying, well, couldn't I just pretty much extend the probation period for 2 years? Theoretically, you could do that, but what a tribunal, a judge would probably consider was, is it fair and reasonable for you to do that? What is it that you're trying to ascertain as an employer during that probationary period? Is it that your candidate is able to demonstrate that they are able to carry out the role at the necessary standard? If they're able to do that within 6 months, then it's unlikely to be objectively fair for you to just extend that just to prevent them from securing those additional rights. So as it currently is, I think there's definitely that leverage from the employer that even after an employee does become an employee, after they pass their probation, within that first 2 years, employers can still dismiss an employee, provided they comply with their contractual requirements, i.e. pay them the notice pay, and there's quite minimal litigation risk, unless it's an extreme overt reason that would be an automatic unfair dismissal. But as it now is, well, as it will be, as soon as this law is implemented, that as soon as that probationary period is passed, that the protection that an employee would get after 2 years, they'd get that automatically. So there's going to inevitably be a requirement for employers to be more cautious and just be mindful that employees that potentially could be problematic, that wouldn't have been discovered until later down the line, as soon as they have that tick box to say that you're an employee of our establishment, they get all those rights they would only get after 2 years. So there's definitely going to have to be some ways they can potentially look to mitigate that with policies. incentives for employees, that rights, benefits are obtained after certain periods of time, things like that. It's all a bit into the unknown at the moment, but yeah, it definitely could be present a lot of new challenges for employers.
Can I just say something? Sorry, because Julian, basically people are employees from the moment they start, so the probationary period is irrelevant in that respect. It's just employers often get confused by it, but someone is an employee from the moment they start, and they, uh, you know, the government I've heard are going to be doing consultations, by the way, on whether the probationary period can be used to delay to so that the right to not be unfairly dismissed is actually potentially going to come in after the end of the probationary period, actually. So they are, I know they're consulting, and I know they have been consulting. So, I think right now employers are clearly in an invidious position because they just don't know, and we don't know as employment lawyers. We don't know either. But I have heard that they're going to be consulting. But as far as probationary period is concerned, extending that to sort of 2 years, there's just that wouldn't do anything. That wouldn't change anything. So the probationary period is something that's used, referred to in contracts of employment, just so that an employer can have built into that a different notice period as they require, so that if somebody is dismissed in breach of the contractual provisions in regard to their probationary period, that potentially gives rise to a breach of contract claim. But really, I think just as an employer, don't be too kind of comforted by this probationary period issue, because it doesn't give, as previously said, it doesn't give a statutory right. There's no statutory provision to do with probationary periods, as far as I know.
I guess when they get into the detail of it, they might decide, because they definitely have mentioned something around probationary periods and how those could potentially be used. So I wonder if they're going to come up with some halfway house during probationary periods where there's a set process that employers are expected to comply, potentially during that phase, and perhaps the unfair dismissal, provided that the probationary period is specified in the contract, and they'll probably put a maximum number of months that you can have a probationary period for, I suspect, so to avoid the situation where people are doing 2-year probationary periods, because it gets them out of going through the full disciplinary procedure or whatever they're required to do, whether it's conduct or capability or redundancy. I did see somewhere that potentially the probationary period would be up to a year, but I don't know. Nobody really knows any more than that. But I think because they've mentioned probationary periods, I have a feeling that something different might be set up for that. That might be put in statute. I don't know.
Yes.
Natasha.
Sorry, Natasha. Yeah, sorry.
That's okay. Hello. I was just going to add on to what Ross just said. I agree. I think that we will find out more about what's going to happen with this probation period, and I think that is going to be really key to this change coming in, because on the face of it, it just it's terrifying, isn't it, for employers not knowing what to do with this situation, and we're definitely going to need that detail soon. But I was just going to say the other thing to bear in mind is, as well as obviously policies and contracts and everything being updated, I read an article somewhere that was talking about the impact on even ACAS, and getting ACAS's agreement and changing their code of practice, because obviously so much reliance is put on, although it's not a statutory thing, it's obviously heavily relied upon in any tribunal if it's not being followed. So I think that's going to have a really big impact on the timeframes involved in these changes coming into effect, because that's the disciplinary code is obviously going to have to be updated, or a whole new one drafted that's going to reflect the new way going forward. So just I thought that was quite an interesting point to raise.
Yeah, I think the ACAS code, Natasha, is very important, because of course it's primarily both disciplinary and grievance. So you'll see it used and deployed from both sides of the fence. Employers will want to rely upon it in order to shore up their defences, that they've got their house in order, and that they are approaching things to ensure it's a substantively fair dismissal. And secondly, that the procedure they're followed and adhered to is sufficient. Employers will point to the opposite, and they'll raise grievances, and then they'll follow an appeal, partly to try to justify the continued employment, and secondly to ensure that they get the maximum 25% uplift, and they'll point to the employer's breach and so forth. So I think both sides will be scrutinising the policies. What is clear, I think, is employers will need a lot more thought in terms of their policies, their documentation, very regular reviews. In a normal way, a lot of probationary periods can be extended. I think they'll want to look at that. They'll have things diarised. There'll be a lot more contact. But these are only points that go into the melting pot, aren't they? If it's a day one unfair dismissal right, if it's a say 6-month unfair dismissal right, then it's open season. You can follow whatever process you like prior to that. So the devil's in the detail. Fine. Okay. Did anybody else have anything to say on the unfair dismissal?
Sorry, I would just finish up just on that point. I've shared the document in the chat. Probably many
Thanks,
people have already seen it already. It's just the Labour document with their proposed plans, what they how they intend to make work pay. And on the probation point in that, it does, obviously, this could still be changed, but it does confirm that with probation, these new proposed changes won't prevent a fair dismissal in a probationary period, provided that there is a fair and transparent process and there are fair and transparent rules. So that's not to say that they couldn't shift from that position, but hopefully that's a little bit of solace for employers, that obviously not to abuse a probationary period, but that it still is to some extent a means by which they can use it to examine the suitability of an employee, and provided they have the fair process and the fair rules and it's transparent, that they could potentially dismiss an employee prior to that probationary period coming to an end.
Thank you. Thank you. There's no particular order to any of this. The next one I was going to mention was the right to flexible working as a day one right. I mean, obviously, people will be aware that flexible working right became a day one right in April this year. So this is not novel territory. This is pre-existing. This is with us. But what I think has changed is the direction of travel. Is the Labour government has said that it will now be a default. So it's, I think, going to be even harder to justify objectively a business reason not to accept a request for flexible working. And of course, that's likely again to raise issues of assertion of statutory rights, whistleblowing, discrimination, and so forth, because it's linked increasingly, I think, to sort of those workers with caring responsibilities, children, parents, both ends of the spectrum. So it's going to get, I think, harder. I mean, what I'm reading is the expectation is going to be much harder to object. So, I mean, I don't know what people's experiences already are, or what their views are likely to be of the future. George, if you be quiet now,
I don't have much experience in this respect, but the wording Labour have used in their plan to make work pay is that it'll be the default unless an employer can show that it's not reasonably feasible, which I think, like you say, leans towards significant raising of the bar from not just necessarily having a legitimate business reason to refuse, but actually demonstrating that there's no reasonable accommodation that can be made to make that impossible. Obviously, we don't really know at this stage how much of a bar raise that's going to be, but it seems like, to me, that opens the door to quite a big movement. So I don't know what other people think, but I'm with you on that. I think a lot of it is aimed at people with caring family responsibilities. It opens the door to a lot of those sort of claims. But the word not reasonably feasible is very, very different to, I think, the existing grounds for refusal.
Yeah, my own perception is that a lot of these rights inevitably are about one's perception, and that's a fertile ground for dispute, because somebody's idea of what is reasonable and justifiable objectively is sometimes not somebody else's, and particularly where you've got an employee who is saying, I have these other issues that they are pressing and they are important, and I have to balance them with work because I have particularly, should we say, caring responsibilities. And suddenly that's going to be given very much more prominence, and now statutory, or in existence already, I think, statutory enforcement of those rights. So I think it's going to be very tricky. Does anybody have any experience of where employers have pushed back on that, either successfully or unsuccessfully?
I have. This was prior to this, obviously, and it wasn't. It was, again, the test wasn't the same. It was just whether or not it was essentially reasonably practicable for the business as a whole to implement that adjustment for the flexible working. And I think what that boiled down to, the employee in question didn't have caring responsibilities, but she had disability. It was a protected characteristic, and that's something that I think is quite significant for this. In that, obviously, people with caring responsibilities, considerations will have to be made for that. But people with protected characteristics, I think employers are just going to have to be very mindful and cautious to ensure that they are taking all reasonable steps to facilitate flexible working, if at all possible. And I think with how advanced technology is now, the number of roles that you cannot do flexibly is quite limited. So there does have to be quite significant business reasons as to why a request can fairly and reasonably be rejected. Sometimes it's even a case of compromise or just attempting something. But yeah, I think everything's going to be on a case-by-case basis. And then you've got that challenge of whether it's objectively feasible or is it that subjective view. It's very difficult, and it's hard to just give a concrete answer.
Well, with disability, that comes under duty to make reasonable adjustments. So most of the time, flexible working is agreed with someone who has the protected characteristic of disability, because that falls under the legal obligation to make reasonable adjustments where somebody has a disability. I mean, I think on flexible working, at least from my point of view, because I have spent years campaigning for flexible working in the early part of my career when I was working for Maternity Alliance and working with the Equal Opportunities Commission. This is a really welcome change, and I think that so many employers are doing this anyway because they're seeing the light post-pandemic, and they're seeing that work can be done in a different way. But I think clearly where you get people, so I've been advising employers recently where there's been a couple of people who've asked to walk their dog in the mornings because they're looking after a dog that belongs to their mum or something like that. So they want to come in at 10 o'clock. So I think so refusing that is presumably still going to be feasible. The reasons for refusal need to do with the needs of the business. And so as long as the employer can justify from a business point of view, and their refusal is not going to amount to indirect sex discrimination because of a caring responsibility to do with women and children, there shouldn't be any risk to refusing the request. So I think it's only the risks for our clients, employer clients, are to do with indirect sex discrimination claims, potential, and disability. You're right. So those are the ones I identify. But anyway, if anyone else has got any ideas.
I noticed in the document, the Making Work Paid document, it says the government has recently implemented some changes to the framework for flexible working, what the Conservatives did recently, and we will adapt and build on this baseline to ensure flexibility is a genuine default. So it's almost, I don't know if it's a bit like flipping it on its head. So when you're advertising for a job, you don't put anything about hours, and then the person comes in and you say to them, okay, so ideally what hours would you be looking for? And then you take all that information away, and if you have a reason to sort of say, well, that's not going to work, then potentially there will be a provision of some sort of reasons to justify why, as it's sort of kind of like the flexible working request in reverse, isn't it, almost? It's, and whether they'll stick with the same reasons that are currently in place, the 8 reasons, justifications, and that's the reasonable kind of reason for rejection, or if they'll adapt those, I don't know. I suspect they'll probably adapt them and make it more difficult to say no, because it is actually quite easy to say no at the moment based on those justifications. So yeah, I don't know, but they're going to have to put something in place that elaborates on the word reasonably feasible, because it's so subjective. It's like reasonable adjustments. What's reasonable for one person isn't reasonable for another, but you've got to find a way of justifying it. So yeah, they've got a lot of work to do in the detail here, haven't they? I mean, there's no way they're going to be able to implement any of this within 100 days, even with, you know, even in 6 months, I would suggest. It's bonkers.
Well, one of the things I'm been exercising me is I can see so many positives. I mean, you only have to look at your own business and your clients' businesses. There's so many positive attributes by making things flexible. You're able to reach out to a wider workforce. You can make your own business more attractive. You can retain people. You can recruit people. Provided, of course, you can provide your services more flexibly, because often businesses adapt to what their clients' expectations and needs are, and you know, that sort of has to be the hallmark, I guess. But where I can see negatives, which are difficult to balance, is where you're looking. If you have loads of different workers working independently from home, they're almost semi-autonomous. It's much harder to supervise. It's much harder to monitor what people are doing. It's more difficult to create an inclusive work culture, which sometimes can be important. I know it is for us, that you want that sort of commonality and comradeship, if you like, collegiate working, but also sometimes it's difficult to support people because you're not actually aware if they're not looking as though they're up for it that day, and you need to sort of think to yourself, do I need to just find an excuse to put my head around their door and just see if they're okay, if anything's going on in their lives. You can be blissfully unaware if all you're doing is talking to people on the phone or by email, even by Zoom. You know, it's so there are issues, and I think sometimes there's a friction in both the positives and the negatives, and I think it will just have to wash its way out in due course.
Well, so many employers have now said, no, you have to be in the office, haven't they? And you have to be doing 9 to 5. So many have reverted, but I'm surprised the tribunals aren't full of claims as a result of that. But no, I mean, all those points are really valid, and I think, and there's lots of debate, isn't there, at the moment about the effect of having so many staff at home, all of which you've just described. Yeah.
Yeah. Yeah, I mean, I have, yeah, I think there's friction, and as always, there's no easy remedy, and possibly one size doesn't fit all, certainly across different occupations. Yeah, does anybody have any thoughts on the statutory sick pay? And it's a day one right of sickness, because to state the obvious, this will increase employers' costs, but of course it is designed to be very advantageous, and possibly reasonably so, to employees. What are people's thoughts about that?
I think it's quite a risk of saying I think it's quite a good change overall. I know from an employer's perspective, it will increase costs, and there'll be that fear that, you know, if people are being paid, then they won't be as committed. You know, they have the odd day, those odd days off can add up, and all of those things. But I think overall, I think it's a really positive thing for the workforce generally. Because I think for some people, I mean, statutory sick pay from an individual's perspective is not a huge amount of money. I don't think there's a huge incentive for people to take a day off if they're not getting their full pay. And I think it actually will there are people that are very committed, that do force themselves into work when they're unwell because they can't afford to take a cut to their pay. So I think it's a good thing generally. Yeah, so out of all of them, that was the one I thought, oh, okay, yeah, I'm happy with that relatively, but I'm not an employer, so I can understand why employers might have a completely different take on it. If that can all add up significantly over the year, perhaps.
I think there's a bit of a knee-jerk reaction, isn't there, to say, oh God, this is going to be horrendous. There's going to be loads of people taking odd days off sick here and there. The reality is that's probably not going to happen. Most people don't do that. But as you say, Natasha, if there's somebody who may or may not be well enough and is working from a well-being point of view, then it's probably, like you say, it's it stops that from happening. It's and I think if somebody, it's 3 days at the end of the day, isn't it? 3 waiting days, I suppose, if it's a continuous period, but then odd days may add up. But then, employers do have ways of managing sickness absence through policies and procedures and that kind of thing. It's not, people can't just expect to have every Friday off sick, getting statutory sick pay, and not expect there to be a consequence, because there are ways and means of dealing with that if employers act on them.
Yeah, exactly. I think that employers will just have to act in the same way they would if they notice that pattern of people taking, regular Mondays, regular Fridays, whatever day of the week, but obviously Mondays and Fridays can become quite obvious. Then yeah, they'd have to address that in their normal, attendance reviews, performance reviews. Yeah, so I think it's a positive actually, that it can be dealt with properly if it does arise.
Yeah, one thing that I've already had inquiries about is employers who are perhaps, should we say, not on a generous scale. I've already asked whether they could change their contracts so they will no longer provide contractual sick pay. So they understand they will be liable for statutory sick pay. But broadly speaking, for most people, it is paid at a very much less attractive rate, which is why there's a disincentive, even if you're quite unwell, not to turn up to work because you financially you get clobbered. If people, at the moment, I think we don't know whether the government are going to increase the statutory sick pay level, because it really is pitched at a level, it's a safety net only. It's certainly not a living wage or anything like it. I mean, most people couldn't possibly exist on that if there was going to be a repeating pattern of illness. But I was quite surprised. But again, I think perhaps it's slightly alarmist, but I was quite surprised to get that sort of inquiry. What do people think about the right to switch off and to disconnect? What are people's views generally on that?
I think there'll be lots of opt-outs if you can have an opt-out agreement. Don't know how it works in lots of other countries that have brought it in. Does anybody?
We obviously don't have an international clientele, but I think the what I'm reading is that the government say that they're going to be looking at the European models, aren't they, to see how that works and how that might be introduced. I think this will be quite challenging for a lot of employers. I think some very bad employers whose expectation, indeed requirement, is that employees don't switch off, that they are required to carry on working, not just into the evening, but also at weekends and so forth. So as opposed to voluntarily wanting to stay in touch, it's a requirement of the role. So it'll be interesting to see how this is rolled out. And as you say, what form the opt-out may take, and employees' rights generally with that. One thing I was going to mention, mindful of the time, is the proposal about the obviously there's family leave changes, but I'm particularly interested in a new single status of worker, because I think that is, if you go from employee, worker, self-employed, and that puts to one side, if you like, office holders, directors, trustees, people sort of volunteers, even people working in sort of hybrid groups, but you narrow it down simply you're a worker or you're self-employed. I think two things will happen. Firstly, surely that draws through a huge range of statutory rights now to workers, which are limited to employees. Secondly, you're going to have people perversely who don't want to be taxed for NICs and so forth as a worker, who will actually opt out and say that it suits them to be self-employed, which sounds counterintuitive and possibly against what the government's plans are intended to, the sort of protection it's intended to provide. What are people's thoughts on that? Anyone?
I hadn't actually thought about all the volunteers and trustees and all of that malarkey. I'm hoping that they won't touch that. I think they're just looking to sort out the kind of casual labour force, who are this weird worker status that's almost impossible to work through. Is, what's their tax status, what's their employment status, what rights do they have? It's I think it's a bit of a minefield at the moment. It may help to simplify the situation by just having one status of worker, and then if you're not a worker, then you're self-employed, or you're a volunteer, or you're a trustee, or you're a director, and that kind of thing. So I don't know. I mean, yeah, that was my initial thought.
Should prevent the courts being filled up with litigation on the subject. But I mean, that's not the reason the government are going to be doing it. I think there is such a grey area, isn't there, as to we're always having to advise on employers being cautious that they're not giving workers employee status. So this will be a useful clarification. I mean, the government did provide some guidance, didn't they, earlier on this year, which was relatively helpful. There's a good document on gov.uk, but just saying what's an employee, what's a worker, and so that's useful for businesses. But yeah, I mean, I agree with the earlier comments that anyway, an unknown territory really, but useful from not bringing up the tribunals. I would hope.
Yes, yeah. Any other views on that?
I just think I echo what you said about the challenges in people classifying themselves in the correct states of what's going to be beneficial for them. So if it is that scenario whereby a matter has proceeded to tribunal on an issue of employee status, then it's very much a unique case by case analysis of what the situation is. So I just think it seems ambitious that we think we can just lump everything into one status, and it's going to cover all these scenarios where we do have to look at it. Everything's quite bespoke to see the level of control the organization has and vice versa. So I think it's not going to be easy to do this in a way that satisfies people. But yeah, I'd be interested to see what the actual framework is and how it is done, because at present I just think it's a significant task that they're looking to do.
They haven't mentioned anything about IR35, have they? It's always a challenge one. They dodged that one.
Yeah. Yes.
Yeah. Yes, because it will have an impact on HMRC, and that's going to be a major piece of work. So this is not within 100 days either, is it?
No. No, because like you said, I think, Chris, that if people start declaring themselves as self-employed, then that where do they sit if they don't want to be an employee, they want to be self-employed, but they don't comply with the IR35 rules, and then in the Inland Revenue are going to be up in arms that they're going to miss out potentially on a shed load of employee and employer tax.
Mm.
And the danger is you have that usual demarcation between the tribunal cases and the legacy of cases which go to status, and ranging way back to master servant all the way through, and now they've been adapted and coming into the gig economy and sort of looking at sort of Uber drivers and you name it. They're trying to adapt to modern society, and you've got the way the Inland Revenue approach things, which is not always uniform. They don't always pull in the same direction. You can have different answers, and the danger is that you implemented two aspects. You're either a worker or you're self-employed, and the parties will agree upon that right up until the point there's if you like, a termination of the arrangement. And then the self-employed person will say, notwithstanding everything that we've agreed and said before, it now dawns on me that I'm actually a worker, and therefore I have those statutory rights which would otherwise be denied to me. And then you've got to unscramble perhaps what has happened in terms of the tax, or at least account for it in a different way. So you're not necessarily going to have a get out of jail card as an employer, unless you go into some sort of binding arrangement at the beginning via a settlement or otherwise. And you can't normally contract in or out of those sorts of rights. Yeah, they're factual. You have them or you don't. So I'm very interested in this line, because I think it could be hugely influential in the advice we give to clients, and the way our clients' businesses are set up, and the impact on their arrangements, and particularly their finances. Watch and see, I guess. Yeah. I don't know if anybody had any thoughts on the increased protection from sexual harassment. It seemed to me quite an interesting one. There's going to be this, we already have this proactive duty for employers to take reasonable steps to prevent employees from facing sexual harassment. But it seems the government plans to extend that protection to take all reasonable steps to stop sexual harassment, including harassment by third parties, such as customers. Now, I suspect if you're in retail, or there's very much more customer interaction, that could be very challenging, because often it's outside your your ability to prevent that. Somebody just walks onto your premises, and if they're being extremely difficult, provocative. They're harassing and they're harassing somebody. It's not as though you've, in the broadest sense, given them a license and permission to do that. They've just literally, they've just walked in. I'm no
I
idea.
think there'll be lots of, sorry, Chris, there'll be lots of posters up and around, won't there? Everywhere, any shop you go into, it'll be,
people will be frog marched out.
Yes,
Yeah.
it's lovely to see that. Yeah.
It's the EHRC, isn't it? That who are the people, who are the body that have put in this very specifically. They've referenced third party harassment. So rather than the legislation itself, because everyone was thinking, because that whole issue of protection from third party harassment was debated massively in when it's going through Parliament, and then it was taken out of the last iteration of the Act. But then the Equality and Human Rights Commission have put it into their new code of practice. But it's a draft code at the moment, though. But I doubt it'll get taken out. So I think the bottom line is employers are going to have this issue to prevent third-party harassment. So maybe there'll be lots of opportunity for training courses for lawyers and HR professionals.
I had there was a situation recently, and I think the retail is a good point, or generally anybody that works in kind of customer service is potentially at risk of harassment. And what do you do about it? You haven't got much control over them.
And hospitality,
hospitality as well. But when so if you have if you're a business that has clients, and this particular case, the employee was felt that the client was behaving inappropriately, and the client was making her feel uncomfortable, and the client pays the company a lot of money. So I think those are much more difficult situations to resolve, because where does the duty to protect your employees end when it comes to potential loss of revenue? And being in a particular case, it might be the death of a company if they lose that particular client, refuse to work with them because of the way they behave, but their hands are a little bit tied. Obviously, they can have a difficult conversation with that person to say that they think that they're behaving in making people feel uncomfortable because of the way they're behaving. And then the client just decides to take their business elsewhere because they don't like being spoken to like that. And I found that especially on an international and a global basis, because there are so many different cultural expectations in different areas of the world. And so what we expect in our country, in this case, it was an Eastern European country, is very different to the way that senior men behave, in this case, in Eastern European countries. So I think that one for businesses is a more challenging business issue to resolve. So I don't know if anybody's had any experience with that kind of thing, and how that's, a case that's actually worked through, if there's any employment lawyers who have that.
But Ros, are you saying that the company therefore wouldn't, because by analogy you're saying that they would be putting up with their employees being exposed to sexual harassment?
Well, I'm saying, what are they expected to do? Because no, of course they shouldn't do that. But what realistically can they do? Then they remove that. In this case, they remove that person from that particular client interaction. So their job had to be changed. Or the other alternative they talked about was that person had to be accompanied at all business meetings with this client by another member of staff. And that is what they ended up having to do. In the end, I think in the fullness of time, she decided to move on, and she resigned, despite the steps that they took. But it was really difficult to deal with, because they have no control over this third party. So by default, the employee is suffering as a result, because their job has to change, and maybe they don't have the same access to that particular client work, which is really interesting and really developmental for them, because of the behaviour of this client. I'm not saying that they should put up with it. Absolutely, they should not. But what is a business I think that's the conundrum. How do you, what is the resolution in that situation that's satisfactory for everyone? There isn't one.
It's back to the never-ending argument of what is a reasonable step, isn't it?
Yeah, exactly. All reasonable steps.
Yeah.
Yeah.
So it might be reasonable to move them off that client account to the business because it solves a problem, but it might not be reasonable to that individual who actually wants to develop and wants to progress, and that is the only account where they'd get that, exposure to that work. It just seems like a no-win situation.
Essentially, if we were advising the employer, we'd say obviously their duty of care to the employee would be the superseding priority that they have there, and failure to take that reasonable step could inevitably put them at significant litigation risk just from their own employee. And in sexual harassment matters, when these new changes come into force in October, they could be looking at a 25% uplift as well. I understand that scenario you've just said. Obviously, if it's a key client for the business and it's going to be detrimental for them to lose that business, but from their position as an employer, that duty to their employee is paramount, and it's a very and I think, like you said, it's a situation where someone's going to lose out significantly there. But yeah,
it's just a really difficult conversation to have with a client when you're saying, well, you've got to do what you've got to do, and they say, well, I'm going to lose this business then, and then I won't have a business.
Maybe culturally as well, would the employer want to be perceived by the rest of its staff as someone who would pretty much...
and I get all of that. I absolutely get all of that. I totally get it. I've worked in HR for years. I'm just saying, from a business perspective, this is really difficult to reconcile. And I was just putting it out there if anybody had any experience of a successful resolution. In my case, it was reasonably successful. They kept the client. There was somebody else who didn't find this person offensive in any way, shape, or form, even though the behaviour was exactly the same. And there was this interpretation of that this employee was being oversensitive. They did the steps anyway. They did what was required anyway to protect her from feeling the way that she felt. And it didn't damage the business, but she left. So, it kind of did in a way. So I just wondered if anybody had a successful resolution of a situation like that.
The only one I can think of did result in an exit. So, successful in that it was all wrapped up and no risk to anybody, but not in terms of that person being able to carry on as they were originally.
And they should get rid of that client as soon as possible.
Well, but what if they can't? What if it's a multi-million?
No, I'm joking, Roz. I was slightly tongue in cheek because of course, if that client's biting into your business, I think it's just a question of communication and client relationship in that. So somehow they need to find a way to address that with the client in as positive way that they can. But having a zero tolerance approach, as you say, you've done HR for many years. That is the overriding message, and what they should be doing. So in their terms and conditions of service with their clients, just include that. That's what employers are going to have to do in the future, I think.
Yeah, I think they are, and flag it. I think there's certain implication from the what's proposed is that there has to be an overt kind of communication about whether it's, if it's training for small companies, they might not have the training option if there's only 5 employees, for example, but flagging the policy, an updated policy on harassment, and overtly flagging it, not just sharing the handbook or whatever, but actually flagging this particular policy. And so perhaps in terms of the client's relationship, that is a flagged expectation. But the problem in this case was that he wasn't doing it to be predatory, or that was just his MO in terms of the business world. It's how he spoke to everybody, and some people found it difficult and uncomfortable, and some people didn't. So I'm not sure that even if you flagged the policy to him, and the expectation, he would read it as saying, okay, yeah, that's fine. You know, I don't do any of that stuff. There's kind of like the level of awareness and expectations across on an international market are just, yeah, they're different. And that's another complexity that kind of throws into the mix. Because I think if it was a UK based client, then it would be much easier to deal with.
Well, one of the problems you've always got with this sort of line in this area is that harassment often is perceived, it's a subjective quality, isn't it? And so what affects one person in a particular way, and they say that's totally unacceptable, and they really put the foot down, and somebody else is a bit more blasé about it, or more confrontational, and just says that's got to stop. But everybody reacts in a different way, and I think employers are going to have to be a lot more astute to stamp on this, or to recognise it in the first instance, to have lines of communication, open communication with their employees, so that they're familiar with what is going on at the coalface, and be seen to be supportive, and then of course they're going to have to take appropriate steps. But as always, it's going to be a balance, isn't it?
Yeah. No easy answer on that one.
No easy, indeed. And that should be a strap line for the end of this call. I think we've punched through the hour. So unless anybody had any last final comments.
No, but thank you. Thanks for the discussion.
No. Yeah, thank you. It's going to be an interesting and very busy year, I feel.
It is. Yeah. A lot to be determined.
Sandy will be back next time, so hopefully there'll be a much more a smoother operation next time. But thank you all for joining. Okay.
Thanks a lot, Chris.
Cheers.
Take care. Bye, everyone.
Bye.
Bye, everybody. Bye.
Bye.
Bye.